If you adopted a child from outside of the US, now they're physically in the US, you're wondering how to get them citizenship. Well, in this video, I'm going to break it down for you because it's going to depend on the category they came into the US with. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. So today's video is part of my series on getting U.S. citizenship for your children. And this is specifically for parents that have adopted a child from outside of the U.S. and are now looking to apply for citizenship for them. Like I said earlier, it is going to depend on the visa category they came in with. And if you want to know what category your child entered the US with, look at their visa and it will tell you what you need to know. There are three options that an adopted child can come into the US with: either an IR2, an IR4, or an IR3. An IR4 may also be listed as an IH4, or an IR3 can also be listed as an IH3. So it's really important that you know the visa category that your child came into the US with. So what happens once your child is in the US, in your custody, and you are finally done with the adoption process? Well, for an IR2 visa category, your child will get a permanent resident card in the mail. Now, once they have that card, you need to look at whether they qualify for an N600, a Certificate of Citizenship. See, USCIS does not automatically give them a Certificate of Citizenship because an IR2 can also apply to stepchildren of U.S. citizens and permanent residents, and it can apply to unmarried children of U.S. citizens and permanent residents. So the reason that U.S. government does not automatically send you a certificate of citizenship for a child that enters in an IR2 category is because stepchildren can also enter the U.S. on an IR2, and stepchildren do not automatically derive or acquire citizenship from their U.S. citizen step parents. So because of that, USCIS is now going to take the risk of sending a certificate of citizenship to someone that does not qualify for it. So when it's an IR2, you as the adoptive parent needs to take the extra step of applying for an N600 for that child. Now, if the visa category is an IR4 or an IH4, you will get a green card in the mail, just like an IR2, but the child only acquires citizenship after you have done the adoption or the readoption part of the process in the US. So typically a child that enters in an IR4 or an IH4 either needs to have the adoption completed in the US or has to be readopted in the US or have their foreign adoption recognized by a US state. So when you're in that category, the child does not automatically acquire citizenship until the adoptive parents have taken that extra step of making sure that they complete the adoption, the readoption, or have a state court recognize the foreign adoption. Once that step is done, then the child would qualify for an N600. And if they meet the requirements for an N600, you can then apply for an N600 for them and show that they are now a US citizen. Finally, we have the IR3 or IH3 category. If a child enters in an IR3 or an IH3 category and they entered the US on or after January 1st, 2004, that child will automatically get a certificate of citizenship in the mail. So if an adoptive child enters the US on an IR3 or an IH3 visa category on or after January 1st, 2004, USCIS will automatically send them a certificate of citizenship. The parents do not have to go through the steps of filing an N600. And that child is now going to get a green card in the mail. They are going to automatically get their certificate of citizenship. So the first document they have in the US is going to be proof of their citizenship. Now, if your child entered the US before January 1st, 2004, they would have gotten a green card in the mail, right? And you will now be able to apply for an N600 for the child. So for an IR3 or IH3 category, the child either automatically gets a certificate of citizenship, or they automatically get a green card, or the child has to file for an N600. So it really depends on the date that the child enters the US, not the date you completed the adoption outside of the US. So it's about when they entered the US. So on or after January 1st, 2004, automatically getting a certificate of citizenship. If it's before that date, you will need to apply for an N600 for that child in order for them to get proof of their citizenship. Remember, the child is a US citizen. You're filing an N600 to have proof of their US citizenship. In order to qualify for an N600, you have to meet these categories. Again, you only need to file an N600 if you do not have an IR3 or an IH3 visa category on or after January 1st, 2004. So if you have an IR2, an IR4, or you have an IR3 before January 1st, 2004, you're going to need an N600. And in order to qualify for an N600, you need to prove a few things. One, that you are in the legal and physical custody of your adoptive parent that is a US citizen, right? Two, you have to prove that you received your permanent residency. And three, you have to show that you are physically in the US. And finally, you have to meet all of those requirements before you turn 18. So as the adoptive parent, you're looking at whether your child met all the requirements for an N600 before they turn 18. And if they do meet all the requirements, then you can apply for an N600 for them. If you're watching this and you are the adoptive child and you want to know what you can do, you can also file an N600 on your own once you're 18 to show that you are a US citizen. Again, an N600 only gives you proof of your citizenship. It does not give you citizenship. So if you entered in an IR3, IR2, IR4, and especially for an IR4, you have to make sure that they have went ahead and done the adoption or readoption. If those processes are done the way they're supposed to be done, you are automatically a US citizen and you are only filing an N600 just to have proof of your US citizenship. Okay, so this can be done by the parent for a minor child, or the now adult child can go ahead and file an N600 if they have met the requirements. So to go over it again, an IR2 category gets a green card in the mail but must apply for an N600 in order to have proof of their citizenship, and they also have to meet the requirements of an N600. An IR4 or an IH4 has to get their green card in the mail. They must either adopt the child in the US, readopt the child in the US, or have a US state court accept the foreign adoption in order for the child to be able to acquire citizenship and then file an N600 to get proof of their citizenship. And finally, for an IR3 or an IH3, you may not even get a green card in the mail. You may just go straight to the Certificate of Citizenship if the child entered the US on or after January 1st, 2004. If it's before that, you will get a green card and then you can file for an N600 for your child. If you are an adoptive parent or you are an adopted child and you are looking to get proof of your child's citizenship or your citizenship, and you are not sure where to start, what to do, and you know you need to file an N600, or you're not sure if you meet the requirements for an N600, please go ahead and schedule a strategy session with me. We can discuss it, figure out what you qualify for, and if I'm able to help you with the process. You can do that by going to my website, lilylegal.com, and clicking on Contact Us, where you can pick a date and time that works best for you, where we can talk about getting you or your child their proof of citizenship. Because remember, the N600 only gives proof of citizenship. Your child or you are already a US citizen. The N600 is only meant to give you proof of that citizenship.